In our previous two lectures, we have devoted towards war and war crimes. So, in this lecture, I would like to discuss the very constitution and establishment of International Criminal Court, and the very endeavor was started in the year 1937 by the Advisory Committee of the League of Nations for establishment of a High Court for International Crime, and that was signed by Belgium, Bulgaria, Spain, France, Greece, Netherlands, Yugoslavia, and Turkey. General Assembly, after the end of Second World War and its formation in 1945, in the year 1950, entrusted the task of forming a draft code for International Criminal Code, and the draft code as drafted by International Law Commission in 1954. So, also certain developments led to the formation of International Criminal Code, such as in 1977 the draft code submitted by the International Law Commission was in consideration in the General Assembly, and in 1980 the draft code formed the offences against peace and security of mankind, and in 1966 the General Assembly adopted the resolution Elimination of Racial Discrimination Convention, and in 1968 the convention regarding the crimes against humanity was adopted, and in 1973 the convention adopted crime against diplomatic agents, and in 1976 and 79 conventions of crime of apartheid was adopted. So also the convention on taking hostages was adopted by the General Assembly in 1979. The United Nations Commission on Crime Prevention and Criminal Justice was adopted in 1991. Then a World Conference on Organized Crimes was held in 1994, and consequently there was adoption of the Statute of International Criminal Code by the General Assembly in 1997, and finally there was the establishment of International Criminal Court at Rome Conference in 1998 with 128 articles, and the seat of the court was established at the Hague, Netherlands, and it was participated by 162 countries, and the very assembly of the state parties of International Criminal Code statute provided that the state parties having one representative and alternative representative and also observers at the International Criminal Court. And as according to the Statute of International Criminal Court, it shall consider and adopt the recommendations of the Preparatory Commission and to provide management to the presiding officers of the criminal court, the prosecutors and the registrar on the administration of the International Criminal Court. It would also consider the reports and activities of the Criminal Bureau established under paragraph 3 of the statute. So, it would consider and decide the annual budget of the court and to decide and alter the number of judges in accordance the provisions of Article 36 of the Statutes of the International Criminal Court. Also to consider questions relating to non-cooperation as provided under Article 87, paragraph 5 to 7. The International Criminal Court to perform functions consistent with the statute and rules of procedure and evidence. It would to constitute a criminal bureau consisting of president, two vice presidents, and 18 members elected by the assembly for 3 years. It would also establish subsidiary bodies for independent mechanism for inspection, evaluation, and investigation of those crimes by the court. And finally, to enhance its efficiency and the economy of the International Criminal Court. Lastly, if there are no consensus on decisions on matters of substance, it must be approved by 2/3 majority present and voting, and on matters of procedure by simple majority present and voting in the sittings of the International Criminal Court at the Hague, and on settlement of disputes if the method of negotiation failed after 3 months of its commencement. Then it takes other measures. Also refers the dispute to the International Court of Justice in conformity to the statute of the International Criminal Court, and having its jurisdiction. The International Criminal Court would have jurisdiction over the crime of genocide, war crimes, crimes against humanity, the crimes of aggression. Article 21 of the statute provides rules of procedure and evidence, also rules of treaties and principles of international law would be applied by the International Criminal Court, and also it would apply laws on criminal jurisprudence derived from national legal system and the very general principles of criminal law adopted by the International Criminal Code as regarding a person's conduct in question constitutes crime under the jurisdiction of the International Criminal Court. Also, a person convicted may be punished according to the statute. Besides, no person shall be criminally responsible prior to the entry into the force of the statute. And also, Article 25 of the statute provides individual criminal responsibility. And Article 77 clearly provides the penalties could be imposed by the International Criminal Court against commitment of the crime of genocide or war crimes or crime against humanity or the crime of aggression. Article 74 of the Statute of International Criminal Court also provide appeal and revision provisions relating to the judgments and decisions delivered by the International Criminal Court as before International Court of Justice or under the very jurisdiction of the International Criminal Court. So, the very initiative started in 1937 by the League of Nations for establishment of a High Court for International Crimes, and which was signed by majority of East European countries and European countries such as Belgium, Bulgaria, Spain, France, Greece, Netherlands, Czechoslovakia, Yugoslavia, and Turkey. That initiative finally resulted by the General Assembly of United Nations Organization in 1950, which entrusted the task of drafting the very constitution of International Criminal Court to the First Law Commission of United Nations Organization. And due to long effort by the international organizations and in particular United Nations General Assembly, finally International Criminal Court was constituted in 1998 by the Rome Conference, and it was established at the headquarters, the Hague, the capital of Netherlands. So, almost in our 3 lectures that we devote towards war crimes, and finally the constitution and establishment of International Criminal Court. So our discussion on war crimes, and the very constitution of International Criminal Court is completed.